She's one of our regulars here, as you probably know, so welcome back.
Thank you, as always, for having me.
Okay, so we're going to talk about the Stephen Jones case now because the jury's out to lunch in that case. And we're not sure how long they're going to be at lunch because the judge said that the jury likes to take walks as part of its lunch break. I hope the weather in Flagstaff is fair today, but you know, after sitting in court for this long and with this bumpy of a ride, I can understand why some members of that jury might want to clear their heads.
Well, I would love to be on a jury trial. I don't think it's ever going to happen for me, but I think it would be an incredible experience. It is such an honor to serve and to determine and deliberate, and you have a really large role. And I think here it became a lot more complicated when the judge instructed the jury about Jones's prior statements that he originally did not allow to be heard by the jury.
Yeah, I mean, this turned into a real mess starting, you know, in the closing arguments here. And we listened this morning to the prosecutor's closing argument, and we're going to play the defense closing arguments back in their entirety this afternoon. That's where we're heading on the LawNewz Network. But a couple of big bumps in the road happened between those closing arguments and where we are right now. So here's what happened. This afternoon here on the East Coast, this morning out on the West Coast, Flagstaff time, the jury asked a series of questions of the judge. One of those questions was, what does the law say about pointing a gun at an unarmed person? The attorneys went into a lengthy telephonic discussion with the judge about that issue because I think at a minimum the defense team appears to be working remotely today as the jury deliberates. And the judge at one point was asked to resurrect what has been a frequent defense argument in this case, that the jury should be given an instruction about the defensive display of a weapon. The judge has been hesitant to give that instruction in this case, but the defense has been trying to inject it into the proceedings and tried again to do so today. The judge for a moment agreed to do that, but then backpedaled because the defense asked for part of the instruction but not the whole instruction. So they weren't agreeing to get the whole instruction, and then the judge said, okay, fine, the only thing I'll tell the jury in response to these series of questions is you need to rely on your common sense and understanding of how you go about life. Is that a proper non-answer answer to this question?
Well, it's definitely a non-answer answer. It's totally within the judge's discretion to determine how he is going to answer the question. And I understand why he made this call, because the defense said, well, I'd like you to do this, and then he offered to do it, but the defense wanted the judge to remove certain language, and the judge felt that was inappropriate. So it's ultimately up to the judge, and he made the call that he felt was appropriate. There are probably going to be a lot of issues for appeal, especially given the prosecution's closing statement, and it's possible that if he's found guilty, that the Court of Appeals could render a mistrial and say that double jeopardy bars a trial again in this action. So even if Stephen Jones is found guilty, it's possible that in this jurisdiction, when it goes to the Court of Appeals, that they could say absolutely not, the judge should have declared a mistrial based upon the prosecutor going in the wrong direction and prejudicing the jury so much that they would get to have the conviction overturned, which would be tremendous victory for them. We will see what happens as we continue to watch this trial.
You know, I've taken some time here because everybody always sees me shuffling my papers on the desk here, and it's because I'm trying to reference the record as much as I can for those of you who are listening and who might not have all the papers in front of you. It makes me look a bit disorganized at times, but believe me, these are voluminous, as you can imagine. So here's what's going on with this mistrial issue that was the result, as you mentioned, Deborah, of the prosecutor's closing argument. We dissected the tape that we had of the closing argument earlier, and I don't think I'm going to play that back again, but I did go back into the record to see exactly what was said by the defendant and when the defendant said it. So there was a motion filed on February 28th of this year. That's the state's motion to preclude the defendant's self-serving hearsay statements, and this was the root of the keeping out of court of what the defendant had said to various people on the scene. And I reported it as accurately as I could with secondary sources, but here's what's going on. So when the defendant went up, or rather when Chase Jones, who was one of the witnesses who was called in this case, no relation to the defendant, Stephen Jones, when Chase Jones went up to the defendant and asked him what was happening after the shots rang out, the defendant was still holding onto the gun. And I'm on page 2, line 26 of the record here, in case people at home are following along with me or want to challenge me on this one. The witness, Chase Jones, said that the defendant said that they were trying to take his gun. Chase said he would make sure nobody took his gun. The defendant also stated at that time that it was self-defense. So this, according to the record, is the first time that the defendant, in this case, issued the words self-defense or used language indicating that it was self-defense. The prosecution moved through this motion of February 28, 2017 to keep that out because it was hearsay, and the judge agreed. But the defendant's statements went even further, and I'm on page 3 and I'm starting at line 2. The defendant went on to talk to some of the police officers, in specific Officer Park, and Officer Park was able to corroborate that the defendant said, quote, "I'm the shooter." The defendant said that he was, quote, "so scared." The defendant said, quote, "Please help them, I'm so sorry." The defendant also said, quote, "Why did they punch me and why did they chase me?" Those were the quotes from the defendant, and the insinuation there is also that this was self-defense because the defendant was referencing why did they punch me and why did they chase me. So these are the self-serving statements that the state of Arizona moved to keep out of this case, and the judge agreed because they're hearsay. And we've heard from some of our other guests exactly how that works, and if you want to chime in on the hearsay discussion, here's your platform.
Well, this morning, the guest that you had on, I totally agree with what he said. He said that the jury might now think, what else should we disbelieve that the prosecutor has said to us? So this has opened the door for the jury to speculate. Maybe there's other information out there that the jury is the prosecution is keeping from us. I do think that a typical juror just has to make the judgment call here. Did you feel that the response to the boy's action, getting punched in the face and losing his glasses and being chased, was the appropriate response to take a weapon out of your car and start shooting? They might not think, even with this new information, that at the time, right after the shooting, Stephen Jones began discussing that it was self-defense. They might say, okay, but it wasn't reasonable given the circumstances. So it's still, even though they have additional information now, they get to hear that he said it was self-defense right away, they still might think this was a typical night out in college and a boy took a swing and then he ended up deceased. That, to me, is a very big leap that he was able to use this weapon and will get away with a murder based on a self-defense claim that, to me, I don't feel is justified. And with respect to hearsay, you can make the best argument as a defense attorney that something should be kept out because it's hearsay or something meets a hearsay exception, and the judge could still rule against you. So, here the judge gave specific parameters that the defense was supposed to adhere to, and they did. And then it was also assigned to the prosecution that you should avoid it. And once they stepped over that line, there are going to be repercussions. And it's ultimately going to be a question of, if he is convicted, is this a winnable appeal?
I'm going through the defense's original objection to the state's motion to keep these hearsay statements out. And ultimately, this is the crux of the argument from the defense attorneys to try to keep this stuff in. It's trying to say that some of this was an excited utterance, trying to say that some of it was recorded without the defendant's knowledge. Some of it was a present sense impression, and some of it is admissible to show state of mind. These arguments didn't work, and I can understand why they didn't, because in many of these exceptions to the hearsay rule, the statements have to literally be live statements.
Well, that's actually, in New York State, they give some time for it to be an excited utterance or present sense impression.
No, the federal rules, they don't, though. I mean, when they say present sense impression in the federal rules or excited utterance, usually that means I'm watching something and commenting on it in real time. The pen is currently moving across my field of view. But if I go back and say, 2 seconds ago, a pen moved across my field of view, that doesn't work. Because the exception to the hearsay rule is based on a presumption that when someone's describing live action, they don't have time to back up and lie about it.
Well,
so any time to reflect gets those rules out, at least in the federal rules.
In New York State, they give a little more time, and one could argue that it is time to reflect, or the opposite argument is that it happened relatively closely to the statement itself. So I think, again, that becomes a question for the judge to determine, and I can understand why the judge reached this ruling, and I can understand why he reached the ruling saying that now the jury is going to hear these statements. But again, it all comes down to a question of, even if Jones is saying this is self-defense, I once had a case that we won, and the person, it was a fight between a husband and wife, and it was ridiculous, and the husband allegedly hit the wife's car. Of course, I don't believe that happened, nor did the jury, because they didn't find him guilty. But the wife called 911 and said, my husband just hit my car, I'm a domestic violence victim. And the jury got to hear that. Just because somebody claims to be a victim of domestic violence or claims that they acted in self-defense, it's up to the jury to determine if that's true.
So, yeah, I mean, this whole thing has turned into an attempt by the state to keep these discussions out. And then, we heard before, and we've played it several times here, that it just leaves a bad taste in my mouth, and I think a lot of people watching would agree. It just sounds sleazy and dirty for the state to say, let's use the rules of evidence to keep these statements out, and then we're going to tell the jury that they just never existed. That just sounds sleazy.
I'm a defense attorney, so I certainly tend to be pro-defense. That's just my natural inclination. But it could be that this prosecutor made a mistake. I understand that I'm sure he prepared his statement before. Of course, he drafted it and reviewed it. But sometimes you simply make a mistake, or you decide, I'm going to push the boundary a little bit, and either he decided that, or it's what you said, that he really did something inappropriate and it backfired.
So we know that the judge disagreed with the motion for a mistrial, and because again, the defense moved for mistrial and said, hey, prosecutor, you're getting way too cocky here, you went way too far, we want a mistrial. The judge turned around and said, no motion for a mistrial. I went through the state's actual response, which is, let's see here,
Mr. Jones, defense counsel, state are present.
And they're not all
members of our
sequentially
jury
numbered,
are present.
I can understand why now the judge said no mistrial. This was just not an off-the-cuff decision by the judge. Arizona Rule of Criminal Procedure 24.1 says that a motion for a mistrial, a motion for a new trial, cannot be done before a verdict is rendered. That's the way they do it in Arizona. So if that's what the rule is, the judge couldn't just rip up the jury deliberations and say mistrial based on this statement by the prosecutor. The judge could, on the flip side though, and I'm sure that this motion is going to be renewed yet again once, assuming that there is a guilty verdict, and I'm not saying there should be, I'm just saying for purposes of this argument, let's say there is a guilty verdict. At that point, and I think the rule says within 10 days, the defense can turn around and say mistrial because the prosecutor screwed up on the closing. At that point, the judge could hear it, but the judge can't, under the rules, really rip it up in midstream like this.
Well, each state has its own rules, so you've just read us the rule of this state. In New York State, I know that a judge can make a determination for a mistrial prior to the case being given to the jury for its deliberation, so it could be done after a prosecutor gives their summation. I think that we'll have to see what happens. I do think that the jury questions are interesting. It's very difficult to analyze, does that mean that they're pro the defendant, or does that mean that they're looking to convict based on the questions they're asking? I think that you could analyze the question a million different ways. I know that they asked a question about aggravated assault. I think maybe if we had a guess that could show that they are going to maybe have a split verdict where they find him guilty on certain counts and not guilty on other counts.
I'm waiting for that possibility as well, because somewhere floating around here I have my notes on all the different charges. The bottom line is, if the jury feels that it's in its power and purview to grant some clemency, if you wish, to say, hey, it's not first-degree murder, it's not second-degree murder, let's knock it all the way down the chain here for the death of Colin Brew, because, he shouldn't have done it, but we don't think the penalty should be that harsh. I mean, the jury might go for a lesser charge, but if the jury convicts for the shootings of the 3 who survived, and then acquits or on first-degree murder, but goes for a lesser included offense on the death of Colin Brew, it's possible he could wind up getting less time for the death of Colin Brew than for the shooting and survival of the other 3 victims. It just turns into a kind of a weird quirk in the operation of law in this case.
Yeah, I mean, I'm looking at the statute, and, for manslaughter, he could get 4 to 10 years. He usually would get 5 in this state. It could be mitigated, and he would get 3. I do think that based upon these circumstances, even if he is convicted of one of the lesser included offenses, this was a young boy who made a split-second decision that, yes, it did carry on. He got out of the car with the weapon. He turned the flashlight on. He had time to say, stop, I'm going to shoot. And then he claims that the victim did not listen and lunged at him. But this was a very short period of time where this decision is now potentially going to impact the rest of his life. And this was somebody who was new to college, he was new to frat life, he had a drunken encounter, he was sober, somebody else was extremely intoxicated, and he just made a choice that he is going to have to live with. Even if he's found not guilty, he is going to have to live with this for the rest of his life. So when somebody Googles his name, LawNewz is going to come up, and they're going to see that he was accused of murdering another individual. Yeah, and in many of my cases, that's how I feel about it. People make mistakes, and they're entitled to a defense, and sometimes, yes, they absolutely should be punished. But in our criminal justice system here in the United States, I could really only speak to New York because that's where I practice, a lot of things are penalized to the nth degree, meaning that people who could otherwise live a productive life then have a felony conviction. They have to serve some jail time, and it's not like they went out and were looking to kill an innocent grandma. Yes, sometimes an innocent bystander gets hurt, but usually a crime is committed against somebody that's also involved in an act of criminality, which doesn't take away from the loss of life. That's a tragic and terrible thing, but I think that our country needs to examine its system of punishment and the tremendous repercussions that people face as a result of being convicted felons, as a result of spending endless years in jail when they could otherwise get out and be rehabilitated and be a productive member of society.
I think that is a quote that I will pull from Dean Strang of Making a Murderer, because I was there for that case. And at Stephen Avery's sentencing, he said very eloquently, and I'll remember this for the rest of my life, he said, well, Judge, we're here with a conviction. And he said it in a way that only he is capable of emulating. But he said, now is the time to put as much trust on the back end of the criminal justice system, in other words, the reform mechanism, as we put in the jury system. And I thought that his argument was eloquent. Unfortunately, it didn't win for him, but the judge did say it was a very eloquent argument, and I think that was at least human.